welcome everybody. Thank you for coming along to our webinar entitled Protecting Your Packaging Ideas. I'm Katie Roselaar. I'm Technology Services Manager here at the Pack Hub. And I've got the pleasure today of being joined by Nicola Anderson and Georgia Mann of Withers and Rogers. Withers and Rogers are one of Europe's largest dedicated IP law firms. So lucky to have them today. Thank you very much both for joining us. We've got just under an hour together, and the first part of our webinar is going to be sort of conversation and presentation from the two of you talking around these slides. And then at the end, we'll introduce some some questions from the chat and have a conversation that way. In terms of housekeeping, just for the audience, don't worry, all of your cameras and microphones are off, so that's fine. If you'd like to put any questions in the chat for afterwards, Paul will lead us through those. So Nicola and Georgia, I'll hand over to you both to introduce yourselves and to start going through the slides, please.
Thanks, Katie. Sorry. Hi, I'm Nicola, and I'm a partner here at Withers and Rogers. As Katie said, we're a European intellectual property firm, so we deal with patents, trademarks, and registered designs, and we're based in France and Germany as well as across the UK. So I'm a patent attorney and my background is mechanical engineering. I'm also part of our specialist packaging group, and I've worked in IP in the packaging industry for just over 16 years now.
And I'm Georgia. I'm also a patent attorney and I've been in the profession for about 8 years now. I'm a senior associate in our life sciences and chemistry team. So my background is polymer material chemistry specifically, but I work in all aspects of chemical technology, but I'm also a part of the food and drink group at Withers and Rogers and the cosmetics group. And packaging is prevalent in fast moving consumer goods industries. So I've been involved in that throughout my career. So yeah, that's
Great.
me.
Thank you.
So today we'll talk to you about what intellectual property is and the different types of intellectual property rights that there are and how these fit together. But we'll have a particular emphasis on the benefits of an effective IP strategy for your business, and how that works in terms of considering IP in relation to your own innovation and capitalizing on your own innovation, but also considering competitor IP and how to think about that. We have quite a lot of slides. We're prepared to talk about lots of things, but that does mean we won't cover some things in great detail. So as Katie said, there'll be time for questions at the end if there is something you'd like to know more about.
So first things first, we'll just give an overview of what intellectual property is. So forgive me if a lot of you already know this, but ultimately it's a way of protecting your creative ideas. They are intangible property rights. So like a car and a house, they are a property right. So you can sell them, you can license them, you can mortgage them. And ultimately on the large part, it's what we call this balance of interest, in the balance that you get a monopoly right for your creative idea. And in exchange, you have to disclose or share your innovation. And that's sort of the quid pro quo situation. There are some exceptions to that, such as trade secrets, which we'll talk a little bit about later on. But on the large part, that's just a bit of a whistle stop on intellectual property. So, who is this guy? Well, this is Bill Gates, and what we're going to talk about actually now is more of the importance of an IP strategy and your business strategy and aligning them, because ultimately IP is intended to be a tool to protect your business, and it's very difficult to have an it's difficult to have an effective business strategy if your IP strategy is completely siloed from that. So we've put in a quote from Bill Gates just explaining sort of about the importance of an understanding of intellectual property. I won't go through the whole quote because am I right that the slides will be circulated, Katie, just afterwards, or is that just a check?
Yeah, if you're happy to, we can circulate the slides if you'd like. Yeah.
So, and another one that we want to highlight, which is a very short quote but very powerful, is that ultimately a business strategy without an IP strategy is no strategy. So this is to highlight the main theme that we're going to cover as we go through this, but always have IP at the forefront and considerations of your business strategy. And when you're working with attorneys, or if you have in-house counsel, make sure that your business objectives are aligned with your IP, because ultimately that ensures that your IP is going to be maximized and you're going to make the most use out of it to have a successful business. So I'm going to pass over to Nicola to talk through our wheel.
Our wheel, I like our wheel. So you can see the different types of IP rights that there are. Today we're going to focus on patents and designs, as these are the most relevant, I think, to today's audience. And it's good to know about the different how each of these rights works and how they fit together. So patents and utility models as well protect the function of something, how something works. And that might be a product, it might be a process, it might be a method of manufacture, it might be a process of carrying of how a product is used. Registered designs and unregistered design right, on the other hand, are used to protect what something looks like. So that's of huge importance in this industry. And I'll go into the difference between design right and registered designs later on. There's also registered trademarks on here and common law trademarks. The difference between those being that a trademark can come into force simply through being used, but you can gain additional rights through registering your trademarks. And these trademarks can be things like a word, they could be a logo, a picture, they could be a sound, like the Intel sound is trademarked. It can be a smell even. I think there's some tennis balls that smell of freshly cut grass, and that's protected as well.
And there's other rights, and we'll talk about them at a high level now, as they're probably not going to be as useful as the other types of rights that we'll focus on. But copyright, which people will probably be familiar with already, but to protect creative works, and in the UK, this is something that automatically subsists, whereas there are countries where you do register copyrights. Database rights are usually used to protect information in databases that won't be eligible for copyright due to the lack of artistic nature of it, for example. And then we have know-how and trade secrets, which in this industry is also really important. So essentially, a trade secret is a type of intellectual property right that is not known and ideally will never be known to the public, because ultimately that is when you would lose it. But it's a type of right that can give you that advantage, that commercial benefit, because of the fact you're keeping it a secret. So a very common, a famous trade secret, particularly in the food and drink industry, is Coca-Cola's secret recipe. And they made a very clever strategic decision to keep that as a trade secret and to manage that trade secret exceptionally well, because it is still a secret to this day. So they've still got protection for that. And it just shows the longevity and the power that they can have if they're properly managed.
So it's quite a busy slide here, but I think it's a hugely important one. We've talked about the importance of developing an IP strategy, and this is a really good example of how this can be done. Starting with, if you just go on to the next one, Georgia, the conception of innovation is a really good place to start implementing an IP strategy, because this is about recognizing that innovation is happening. So you've got your designers or engineers, they're solving problems, they're coming up with new ways of doing something, or new ways, something that looks new. And it's important really early on in development to just note this as an innovation. That doesn't mean there's something you're going to go off and patent straight away or get a design registration for. It's keeping track of these new things as they're new. And you can't always rely on designers to actually notice that this is happening, because these clever people, these inventive people, might not recognize that what they're doing is inventive, because it's something that comes so naturally to them. So you need recognition of what's happening in these projects and the product development that's going on and the process development. So you might have invention disclosure documents that are filled in. These can be very brief. As I say, it's just about sort of noticing what's going on. You might simply have a spreadsheet of what's new. And the next step is to disclose this to someone in management who's keeping track of these things. Again, not necessarily making decisions at this time about any rights that should be registered, but just making sure that things are kept confidential, just to keep the possibility of, for example, applying for a patent application, applying for a patent in there. As developments go on, because what you don't want is disclosure of a new product or a process accidentally or at a trade show before you've taken the next step of making decisions about whether or not to protect the IP in these new things. So there's the question of whether or not to exploit innovations in your own company. And if you are, and if you're not, you might still want to go ahead and protect the IP. Whether or not it's worth protecting the IP depends obviously on the commercial usefulness. What you don't want, what we'd never advise as a firm of patent attorneys, is just getting a patent or a design right just for the sake of it. Then it needs to be of commercial benefit. But the commercial benefit of that isn't simply limited to getting a monopoly right yourself. You might be able to bring in revenue from licensing your IP rights to other people. You might be able to use them as a bargaining chip. If you're infringing someone else's patent, they might be infringing yours, and there might be you have the option of negotiation there. So you make this decision about whether or not to protect your innovation, and if you decide not to, that's where you can see the publish to clear ground. So that's so that other people can't get a monopoly right over something that you've come up with separately.
And if you do go down the protection route, you're then following, if we follow the flow chart round, you're at the key decision of what type of protection. As we went through on the wheel, there's multiple different types of IP, and you can have one product that might have multiple different IP rights that are possible. So for example, we focused here on patents and trade secrets because we're focused more on how something works in this flowchart, but obviously you also could have branches to trademarks, you could have branches to designs. But ultimately, if you're at that decision point, you want to be weighing up the advantages, the disadvantages, what the commercial objectives are. So for example, I'm going to refer back to Coca-Cola, but obviously patents, which we'll talk a little bit later, they do have a finite lifespan of 20 years, provided you pay the necessary maintenance fees. And for example, for Coca-Cola, that secret recipe, they envisaged possibly having a longer lifespan than 20 years, and they were correct. And actually, if they'd have patented that formulation, then they would have lost that protection after 20 years. So a trade secret actually ended up being a much better commercial decision. But it might be, for example, particularly in a fast-moving consumer goods industry, there's a lot of innovation coming out, products are being improved and more patent applications are being filed, that 20-year lifespan might actually not be so problematic because the product that patent protects might be replaced by a much better product that you've worked on and you're no longer selling it. So those commercial decisions, and to tie back to the second slide, having your commercial objectives in line with your IP is so important, because they are, as Nicola said, you don't want to file a patent for the sake of it. You want it to bring revenue. You want it to be commercially beneficial. So these decisions are, first and foremost, what are you doing with your business and how can the IP help? It might be that you can use them together. You might have a patent for an innovative process, but some of the know-how and some of the trade secret type information of exactly how the optimized process works could be held back. They might not necessarily need to be disclosed in the patent itself, so you could use them in harmony. But when you're keeping something secret, you need to be careful of confidentiality. So make sure that whoever knows the secret, it's a limited circle. Only those who need to know it should know it. And actually be careful of accidental trade secret loss. So education around employees, education around anyone privy to that secret. And even just from a patent side, as Nicola said about you keep it secret for that certain point. And the point is that it's important to raise awareness in that research and development team, because if they're going to a trade show and they're not aware that something is in development and they accidentally disclose something, then that could be problematic over the right that you try and secure. And if you're focused on the patent side, you need to be careful about ownership. So this is particularly of importance if you're collaborating, if you're working with other partners or you're outsourcing to co-manufacturers, anything like that. Be aware of the ownership of the IP, because you want to ensure that you've got that secured at the beginning before you seek protection to prevent any problems later on down the line.
Yes, it's definitely always easier sorting these things out
Yes,
at the beginning, where you know where everyone is and everyone's still under contract and wants to keep working with you.
Yeah. I was going to ask actually about those ideas at the beginning. So if I imagine myself listening to this call, maybe being an innovation manager or a packaging designer, and where you're starting at the beginning of your flowchart with the ideas, are you suggesting to people that they come to you with their sketchbook and their very early ideas? Or will it be a little bit more formed concept? Or would it be when you've made sort of 100 principle proving prototypes? Where should people be thinking of actually approaching you with these ideas?
I would definitely say before a prototype, because usually there's a lot of innovation done in terms of the proof of concept. And actually, we'll talk a little bit later on about this, but it's a really good question, because I think it's important to raise innovation as and when it comes. It might be that you're too early and it's something that could potentially be really exciting, but there's not enough information there to see whether it's got legs. But definitely I think it's just open communication, having a system in place where any innovation, as Nicola said, it doesn't have to be groundbreaking. And these are really inventive people. So anything that they're doing to solve any problem is worth highlighting, because that ensures that you are going to capture as much as is humanly possible. You might not protect it all, because it might not be, when you go to the exploitation decision making, it might be something that commercially you're not interested in and you just publish it. But just having those conversations means that you're not going to miss anything ultimately. It might be you can't do anything with it, but I think it's as soon as you find something out, I would say, unless you want to add, Nicola.
Well, no, absolutely. And that kind of ties into the next thing I wanted to talk about, which is third-party IP, because having that, I mean, you need records of what you're designing in case other people are doing similar things at the same time. I mean, everyone's trying to solve similar problems, aren't they, in different companies? Sustainability, recyclability, all these things. So it's likely that people will be innovating along similar lines. So you will want official records of innovation that you've been doing anyway for this purpose. And if you've got that record, then why not share it within the company? So for third-party IP, we regularly, especially in the packaging industry where things move so quickly, we carry out competitor watches for our clients. So they'll be keeping an eye on patent applications that are published in a particular field, on design registrations that are published, and in different jurisdictions, depending on where they're interested. Or you can also do keyword searching to see if there's particular things that are coming up. And in doing so, you can make sure that you're not going to infringe other people's IP rights, and you can also see the direction that your competitors are innovating in and if they're doing similar things.
And it can also give you an idea of any gaps in that particular industry that might not be being exploited that you might want to tap into. And actually, if you're not aware of third-party IP and you have your blinkers on, you could get yourself into a situation where you've invested a lot of money in developing something, and actually you're blocked from marketing it or commercializing it because you've not been aware of any third-party IP if something exists that could stop you. So it's really important to have that understanding of what other people are doing as well and not lose sight of that.
Yes, and it can make you be much more strategic as well. If a competitor has a broad patent that you think you will infringe, even if you're not going to, if you can come up with an innovation that's narrower than that, that's within that, and patent that, and then even if you're not going to use that, you've got a patent for something that they might want to do, and then you've got a bargaining tool. So yeah, knowledge is power. Knowledge is power.
So now we'll just do a bit of a whistle-stop tour on patents and patent applications. So basically, for those that aren't aware, a patent application is the legal document that basically covers your monopoly right that you get. So they are negative rights. So you can only use them to stop other people from doing something. Someone might have another patent that could stop you. So it's not full exclusivity. You have to be aware of that fact, but ultimately they contain a description which details the invention and possible permutations that you could have. And you have your claims, which are usually at the back, or always at the back, and they outline the scope of protection that you've obtained, and then you can have drawings and things like that within them. So just to give you an idea of what they contain, but ultimately to be eligible for patent protection, you have to be new. So you have to be different from anything that's been disclosed in the public domain. That could be orally at a conference, that could be in writing, any form of disclosure outside of conditions of confidentiality. You have to be new. So it's a pretty black and white hurdle. It's ultimately you have to be different. That's the first hurdle you've got to overcome. The second hurdle is a bit more subjective because you have to be what we call inventive or demonstrate an inventive step. And what that means is you have to show that you've surprisingly in some way solved a problem or brought about an unexpected technical advantage based on the type of innovation that you have. This doesn't have to be groundbreaking. I think there was a situation where it was a squash ball, correct me if I'm wrong, Nicola, but a squash ball, which was usually in yellow, and someone decided that color was quite difficult to see on the screen, and they actually got patent protection for a specific type of blue squash ball, which was more visible. And actually, because it solved a problem and there was a technical advantage, they were able to obtain a patent for that. So it doesn't have to be revolutionary. So but you do have to demonstrate something that is surprising. So it can't be considered as a routine modification, for example, or obvious workaround or experimental within experimental error. So that's your second hurdle. And then we have industrially applicable. So in this sector, pretty much everything that's being done is likely to be to meet that hurdle. It just has to be capable of industrial application. So it's a pretty easy one. We talk about not excluded. There's some aspects that can't be protected. So this affects more sectors than others, so some sectors more than others. So for example, in the pharmaceutical medical sector, you can't protect methods of treatment and methods of diagnostics in the UK and Europe. But it might be that it's against sort of moral, anything immoral or anything going against public order. So it's important to be mindful of what you're protecting. But in the fast consuming goods industry, I would have expected there to be not as many exclusions, but that is something that, yeah, talk to your attorney or your in-house teams to help kind of help determine if something falls within that category. And then finally, you have to sufficiently describe your invention. So what that means is you have to have enough information such that when your patent expires, someone could pick it up and they could work the invention. So it's got to be clear and sufficiently described. And it's part of that bargaining chip I mentioned at the beginning, where in exchange for that right, for that finite period of time, you have to disclose your invention. You don't kind of get the right without sharing. So that's essentially just a very quick on how to get patent protection. And then here's just a couple of examples from different sectors of things that you could get a patent for. So for example, electronics, you can protect processing, you can protect apps, you can protect software. In the mechanical industry, you can protect plastic bags, you can protect hinges, corkscrews. This is definitely more Nicola's. I look at these things and yeah, I wouldn't. And then more my cup of tea is chemical. So food products, paints, cleaning products, films, things like that. So there's lots of different things that you can protect with a patent.
Georgia,
So
I think your slide is one behind because we're
still. Oh, I'm so sorry.
That's okay. Carry on.
Oh, there we go. Yes, I was about to say that, Katie.
Oh, sorry, everybody.
Yeah.
I got ahead of myself. Yeah, so here's just a couple of examples of different things in different sectors, but ultimately it has to be you're protecting how something works. And these are found, as Nicola said, in products or in processes and things like that.
Yeah.
So we'll give you some examples. So I'll pass over to
Yes, we found some
Nicola.
nice packaging related patents with some good examples of the different types of claim that you can have. So it's important when drafting the patent application at the beginning to think about the type of protection that you might want. So to think about who you're trying to stop infringing. So you can have your product claim to the thing itself. So in this case, we've got a Cadbury's wrapper that you can personalize. It's got this pouch you can put a message in. So there's a claim to the product itself. So no one's allowed to produce that product, to sell, import that product. But then there's also a claim to the process of providing that, of making that wrapper. So that's to make it easier to go after manufacturers. So when it comes to enforcing patents, there are protections sort of beyond the exact claims that you have, but it can be much, much easier to enforce if you have the right kind of claims. And here as well, there's a kit of parts claim of providing the wrapper with and the pouch, as in the product claim, but then also the message card itself. So it's just another type of claim that a patent office will allow, because you're only allowed claims to a single invention for each patent, but you're allowed different types of claim around that same invention. So they've got the same inventive concept at heart. They're solving the same problem. And the next one is another example. You've got this Amazon bag delivery system where there's a claim to these individual bag protectors themselves, and a kit again to a box, and then these bag protectors, as you can see in figure 2 there. But then as well, the method of shipping bags in the box. So that's quite strategically written, and clearly someone's thought about all the different types of infringement that might take place and the different people who might be doing the infringement. So this again is where your market research comes in, knowing what your competitors are doing, knowing who your likely infringers are, and making sure that you share this information with your patent attorneys so that they can produce a commercially useful patent. And it's difficult, especially at the beginning of the process. We'll talk a bit more about what actually happens during the patenting process, but we have to try and have foresight, because we can't, I mean, well, apart from the initial 12 months, you can't change what's in the patent application. So we have to envisage what might happen, in not just in terms of patent prosecution and the prior art that might be found, but also what might be happening in product development and how that might change during the life of the patent.
I always felt when I was an innovation manager that this was quite a nice part of the process, because you would have spent a long time developing something. And when it came to patenting something, you'd sit down and with your own patent and think, right, how can we get around our own patent, and then go on again. Yeah, it's quite
make
fun.
something new. Yes.
And then the last example we're going to look at is this film. So, for example, this just shows kind of from a chemical side of things in terms of packaging, what you can protect. So here they've got a film composed of a new material. And actually, an interesting part from the chemical side is you can actually protect things based on their parametric features. So, for example, you can have claims that include the coefficient of friction, the melt index. I would advise definitely talking to a patent attorney about that, because there are some regulations around parameters and the use of those. But it just goes to show there's multiple different ways of describing your invention. And the useful thing about parameters is you might not necessarily have to unduly limit yourself in terms of structural features. So it's just another option that you have. But here they've got a way of making it easier to recycle. So something to note is that if you're doing something that's environmentally friendly, and we're in a world where we are trying to be more sustainable, there's a lot of innovation towards improving processes and improving our carbon footprint. And actually, one of the benefits to that from a patent perspective is a lot of patent offices, including the UK, offer accelerated, in the UK it's called Green Channel, but offer acceleration processes for environmentally friendly inventions. So obviously the downside there is it's important to understand that if you are accelerating, your costs are going to be more condensed. But if you are looking to get something granted so that you can enforce it, or so that you can have other benefits that we'll talk about a little later, like tax benefits, green channel or other forms of green technology acceleration can be really useful. But yeah, it just goes to show that you can actually get a lot of protection for a particular item. It could be the chemistry of it. It could be, you know, as Nicola showed with the other examples, the structural aspects of it and how it can slot together and things like that. So it's important to think with a wide lens as to what you can get protection for. And these are just some real life examples to give you an idea of some of the things that you can protect. So yeah. And then here, we've spoken about different types of claims that you can have to give yourself more robust protection. So this is a visual so that you can see some different examples of categories of claims that you could have. And as Nicola said, they have to all relate. So each patent application has to be what we call unified. So it has to relate to a single invention, but that doesn't limit you in terms of claim category. You could have a claim to a product, and that could be an apparatus, it could be the system, it could be, like Nicola showed with the previous example, a kit of parts would be a type of product claim. You could have a process of, for example, manufacturing the type of product. You could have a process that involved utilization of the product that you have. And we saw a process towards shipping, which kind of looked to target possible importation infringers. So there's ways you can get creative, and this is why it's so important to share as much of your business objectives and your marketing research and anything you know about your competitors and what they're doing with your attorney, so that they can craft appropriate claims that are going to hopefully bring you the most value that is possible. So that's just a visual. But I'll pass back to Nicola now for how we get patents.
How to get one.
Yeah.
So you draft your patent application, bearing all of these things in mind, and file it at your chosen patent office. We tend to do first filings at the UK IPO, occasionally at the European Patent Office, depending on what the client's needs are. And we go for the UK IPO because they provide a reasonable prior art search at the search stage for a relatively low cost. So that first search can be, unless you have your own private patentability searching carried out before you file your patent application, that search gives you an idea of the prior art that you're up against, of how patentable your invention is, and what scope of protection you might actually achieve. And it's useful to have that carried out in the first few months after filing, because at the 12-month stage, that's the deadline for filing in other jurisdictions, but keeping the date of that first filing. So for your first filed patent application, after search, there's an opportunity to decide if you want to carry on. There might be some prior art that's identical and you might just withdraw at that stage. But most commonly you'll carry on to the examination stage, which is when the patent office compares your invention to the prior art that they've found, says, okay, we think this part of it is new, or this part of it is new and inventive, and they send that back to you, and we then argue with them about that and say, actually, no, I think you'll find that this is far more inventive than the prior art that you've cited. And you can go backwards and forwards a bit, trying to increase the scope of protection, or you can just accept what the Patent Office gives you if you're not too bothered about the scope of protection. For example, if you just want a patent to get the tax benefits and you want to keep costs down. And then at the end of that, you end up with a granted patent. Publication takes place at 2 stages. So the initial publication is at 18 months after the first filing date. And that's important because that's the first time anyone beyond you is going to disclose the contents of the patent application. So once you file the patent application, you can go and tell everyone about it if you want to, but it won't be disclosed by the Patent Office until that 18-month stage. And then once you have a granted patent, that's published so that potential infringers can see exactly what it is that they might be infringing, because a key part of the patent process is trying to provide certainty so that people can see people can avoid unintentional infringement. They can see that you have a patent application once that's published and what might be protected there, and they can see what the granted patent is and what they need to not do in order to avoid infringement.
Nicola, just time flies when we're having fun. We've got 4 or 5 minutes until we open for questions. So.
Okay, thank you, Katie. I do want to get on to registered designs, but perhaps Georgia, if I'll just talk about this next slide because that's important. Thinking about jurisdiction and where you can afford to patent something. I mean, we do occasionally have clients, so we say, where do you want this? And they say everywhere, and then we tell them roughly how much that would cost. So you need to do a balancing act, and you have this initial 12 months where anything you file at the end of that, you can claim priority from your initial application, so that any prior art that comes after that initial application sort of doesn't count. You keep your filing date of that first one. So they do give you some time to kind of redevelop and add extra developments in that time, as long as they're kept confidential. We do have some details on costs.
We could, I think, this is just sort of a visual to highlight where costs can accrue, and if you're filing internationally, how that can change over time. But I think for the sake of time, we can skip through these. It's more of a visual display, and just to show exponential costs depending on territories, as Nicola said. You can't patent everywhere, so you do need to be strategic and know what your competitors are doing to give you the most robust, but also, within reason type of foreign filing strategy. So yeah, we'll move on to how to protect how things look, and I'll leave this to the expert.
Yeah, chemistry doesn't call for so many registered design rights. But I've dealt with them a lot over the years, and they're really interesting, in particular because there's 2 different types. So unregistered designs is something that in some jurisdictions just simply comes into being when you've designed something. You don't have to register it as a right. However, it is difficult to enforce. It can be relatively narrow in scope, and in order to enforce it, to stop someone using your design, you need to be able to prove that they've copied yours. So there needs to be some chain where you can prove they've had access to it. And it needs to be similar enough for you to be able to say, look, they've copied this. It also doesn't last very long. In the EU, unregistered design right will only last for 3 years. In the UK, it lasts for 10 years. However, in the last 5 of those years, even if you can't stop someone using your design, all you can do is grant them a license on reasonable terms. So you will get some comeback from that. So registering designs is definitely the way forward. It's much cheaper, right, to get than patents, partly because there's no examination of the design. You just register your design. The intellectual property office in question will look at it just to check some formalities, to check that you've got the right drawings on there and they can see what is intended to be protected. But you don't know what the scope is that you've been granted. And you don't usually find that out until you do some kind of validity assessment before enforcing it. But yeah, it's very quick to get. It is relatively cheap. It can be a really useful deterrent to stop other people copying your designs. And you can protect all kinds of aspects of a design. You can protect the whole product. You can protect one corner of a product if you've it's a really good list of the different types of things that you can protect about the appearance. So you might protect the shape of a window in a pack. You might protect just the color of it. You might, there's all kinds of different aspects that you can protect. And we would normally, especially for important products, we'd file many registered designs for the same one, again, which is relatively inexpensive because in the UK and in the EU, you get these multiple design applications where you can, once you've got the initial one, you can add on further ones for little added cost. So you might do quite a narrow design to the exact product, and then you might sort of think about how to broaden the scope and how other people might seek to design around that. What else have we got? I think we've run out of time. Oh, just if you just show us the M&S one, Georgia.
Oh yeah.
So it's so pretty. It's just a good example of how easily a registered design right can be enforced, in that M&S have 4 registered designs for their light up gin bottles, so that when Aldi released a very similar product, they were able to enforce that, and Aldi were found to be infringing their registered designs. And that's based on the fact that it doesn't produce a different overall impression. And partly this design registration is successful because it is broad in scope. I mean, I'm not aware of anything similar that was around before this M&S bottle came out. So that is a particularly useful design registration.
And I like that example. It's really good. Our first question that we've got, actually, Nicola, is we've been asked, what's a disclosure? What does a disclosure mean? Can you give some examples of what a disclosure is, so that the individual can avoid doing something accidentally and disclosing something?
Excellent question. I'll start, and then Georgia can fill in the gaps. So it's making it available to the public in any way. The example for in terms of patents is something on the shelf of a library. So something in a book or a magazine, it's on the shelf in the library. It doesn't matter if someone's taken the book out. It doesn't matter if anyone definitely has seen it. Somebody could have seen it, even though it's relatively tucked away. There are exceptions for, what's the word? Disclosure by another party where they shouldn't have disclosed it. But unfortunately, accidental disclosure isn't protected. But you can still do something about it. We've had clients say, "Oh, this is on the way to a trade show right now. Can you file a patent application?" And we've done it because it has to be the same day. What else have we had? Yeah, and then actually for design registrations, it is better because there's a 12-month grace period. It is better to register the design before you show something to the public, but you do have time afterwards if you need to. And it's harder now with the internet because a lot of things go on YouTube. A lot of press releases are out there.
Yeah, I think it's really important to be in constant contact and with your sales team, with your marketing team, with any research and development members who are going to any expos. Make sure that everything's aligned and you know exactly what's being disclosed and what can't be disclosed yet, because accidental disclosure is really common. And obviously it's kind of the fight between wanting to get that cool innovation out there and brag about it and talk about it, but then make sure that you don't do that until you've done everything necessary to get any sort of protection in place. But common ones are anything online, oral presentations at conferences, publications, and
But you can develop a product with someone. You just need to make sure that you've got an NDA in place, and even failing that, you wouldn't want to rely on this, but if there is an air of confidentiality, there's a difference between having a business meeting with someone about a confidential product and talking to someone about it in the pub. If there can be presumed an air of confidentiality, then that won't count. But again, it's better to avoid that and have an NDA with them.
Yeah. And if you're not sure, because it's a really good question, because there's a lot of case law around what constitutes a disclosure. So if you're ever not sure about something, then ask the question, because there's no such thing as a stupid question when it comes to this kind of thing. Like, just if you're not sure, ask, and you'll be able to get the right guidance.
It can be questionable even with a patent, say a pack is out there with a particular film on it. If people can't tell what's in the film and you're not shouting about it, then that can be fine. It's what we call an enabling disclosure. Can someone tell what the invention is from looking at it? So, and this again is where secrets come in. It's like whether something can be reverse engineered just from someone else looking at it.
Yeah.
Well, that's fascinating. Paul, did you want to ask some further questions?
Yeah, we got some questions from the floor, so to speak. So this is a question I was going to ask if we didn't have any, which is about patent pending. Does a patent pending statement provide the same protection?
It's a really good question. I think it's what it shows is it obviously you can't enforce something that's patent pending, and what you do need to be careful of is if the patent is no longer pending because it becomes abandoned or it becomes refused and you're still marking it as patent pending, there can be possible implications to that. But what it does do is it highlights that you're innovating, you're seeking patent protection for that particular product. And it might put people on watch or be aware of what they're doing in that particular space. So it can be quite successful as a possible deterrent. But it's definitely something that can be used advantageously. But it's important to be mindful of how you're marking it, and if you're no longer eligible for patent pending status, just to be aware of the markings that you're putting on.
It's an important thing to do because you need to make competitors aware that you have a pending patent application. It affects damages that you might be allowed if you do successfully enforce your patent once it's granted. If you can say, well, they are aware of this product and it says on it patent pending. Really, you should have the patent application number on it. That can be difficult in some cases, and some countries will now allow you just to have a web address for your patents, and you can have a list of them there and what products they apply to.
Okay, got another question about sort of protecting your patents from infringements. So how could you protect your patent from infringement from, say, like a Chinese company, maybe where there's a reputationally lots of sort of infringements going on in that market? How do you protect in that situation?
They are trying to get better in China. So first of all, you need a Chinese patent. And you can use that. They are enforceable. I know that you can have problems with sort of design around, and it is difficult. So that's definitely a case where you consider, well, do you really need to enforce it in China? Is this something that they're importing into Europe? Do you need a European patent to deal with it in somewhere like Germany, where they're actually really hot on Georgia, what's the word?
In terms of
enforcement. Sorry, I've completely blanked on that. Injunctions. Interim injunctions, and impounding, stopping products that are coming in while they sort it out. So that can be easier, but many people do get Chinese patents and do find them effective. But there's also, I mean, sorry, Georgia, do you have something to add?
No, you carry on your train of thought.
Well, it was the cost of enforcement anywhere is something to consider. Patents can be useful even if you're not enforcing them as a deterrent. But the cost of litigation is significant and certainly something to be considered if that's why you're getting your patents.
Could you remind us, just with that geographical question, so let's say I've got a patent in the UK that protects someone from selling it in the UK or making it, or both? Can they still make outside the UK and import? What's the sort of situation there with what it's protecting in terms of manufacture, import, sell?
So they are territorial. So if you have a UK patent, you can stop people importing into the UK. You can stop them manufacturing, selling, using the product in the UK. If, for example, they are manufacturing in Turkey and you haven't got protection there, but you do have a UK patent and it's being imported in, that's probably going to be your best chance. But obviously, if you had protection in Turkey, you could maybe stop the source. So it is dependent on the territory, and to be mindful of the traffic and how things are moving around. And actually, kind of just to elaborate on the China aspect as well, there might be traffic going in and out of Hong Kong. So maybe a Hong Kong application could be also valuable to consider. But it is territorial. So if for example, they're selling in a country like the US where you haven't got protection in place because you're European focused, there's nothing you can do about that side of things, but there are things you can do about things traveling from the US into countries where you have protection.
Yeah. Another excellent question from the audience. Can you renew a patent after 20 years to keep your rights?
So I was going to say no, but you can with some pharmaceuticals, can't you? So you can take this one.
Yeah, so in the pharmaceutical industry, we have something called supplementary protection certificates. So they can be used, for example, to overcome the long it might be that you've sought patent protection, you've got a patent granted, but because of the regulatory hurdles and the market approval and clinical trial aspect, by the time your product gets to market, you're nearing the end of your 20-year lifespan. And this supplementary protection certificate is a way to protect that, for example, active ingredient or combination of ingredients or active compositions for an additional 5 years or up to 5 years. So it depends on when you seek them and whether you're eligible, but there are options in the pharmaceutical industry to go past. But for other things, it's
Yeah, generally,
20.
no, there's a hard stop at 20. But what you can do is when you have file, it's from the filing date, it's not from the priority date. So if you do think you really want that extra year, when you file your initial, say you're only doing the UK, you file your initial GB application and then file another one at the end of the year. Keep the priority date, but the life of that will be 20 years from filing.
Okay. Question about sort of fees. Any guidance regarding fees to create a license agreement from scratch for a new product? I mean, it's quite hard, I guess, it's a case-by-case basis, but can you give any guidance on that?
It might also be slightly out of our wheelhouse, more IP solicitor
IP solicitors. Yes. Yeah, it's whatever is commercially sensible. And there's different types of licenses as well. It will depend on whether you want to be the exclusive licensee, which gives you different rights in terms of the patent, or if you're one of many licensees. And yeah.
Okay. Question around EU patents. Is there an EU patent, or do you need to take out single ones per country? And what happens to the UK if that's the case? Or how does that change for Brexit?
There isn't an EU, well, there is now an EU patent that we are not in. There is a European patent application and has been for many years. So you go through patent prosecution with the European Patent Office, and at the end of that, when you're granted a patent, you validate that in whichever European countries you're interested in. So that's not an EU process, thankfully. So we can still do that and still be part of that. And then that behaves as a national right. So there's no difference between that and your UK patent if you validate in the UK. But yes, there is this new unitary patent that is an EU right, and that won't actually cover all EU countries because some have signed up to it and some haven't. So if you do want that, and that's kind of cost effective if you want 4 or 5 European countries, then you would still need to go to the UK separately from that. And as far as registered designs go, that is an EU right. So post-Brexit, you do need to, all existing EU designs were split out. So there was a UK design if people have paid a fee to register them here. But now you do need to get 2 separate rights for the UK and the EU if you want a registered design in both.
Okay. Probably got time for one more question if it's a quick answer. Sometimes they can be, sometimes they can't be. So the question is, for a packaging designer and innovator to develop a concept, they are likely to need to work with a manufacturer to develop the concepts. Does an NDA offer enough protection to protect the designer's ideas? Are there any other methods of protecting ideas if you need to share them? So it's a real question about timing, I suppose, as much as anything.
That's a really good question. I think what I'd add is that I think with non-disclosure agreements, if the same with any contractual agreement, provided you've got good advice on drafting that together and you've got a professional input to make that really robust, and you make sure that you have a clause in there that talks about intellectual property, talks about the default ownership position, but also considering any innovation that's coming out of that agreement, because it might not just be one product, there might be other innovation, and coming to an agreement around IP at the beginning of that contractual relationship. Because if you haven't got those kind of robust contracts in place and non-disclosure agreements in place, then you could come into some problems around either disclosure or possibly ownership, because ownership's the other one when you're licensing out, if that other company is potentially contributing to the conception of an idea. So I think if a non-disclosure agreement is well drafted, it's robust, and I think as well in the fast-moving consumer goods industry, when you're collaborating, choose the choose a good partner. There's obviously there's going to be risks with anything in terms of who you know when you enter into these contracts, but I think doing everything you can to protect yourself is always going to be the best that you can do. I don't think there's a foolproof way to avoid possible eventualities, but I think if you've got good contracts in place, then you can be very well protected.
Yeah, and there are steps you can take if someone else files a patent application to IP that you believe that you own.
Yeah.
You can deal with that with the Patent Office.
Yeah.
Excellent. Thank you. Good, great answer.
Great question.
Wasn't mine.
So is it time then, Paul, to wrap
Yeah,
up
I
and
think
to thank Nicola and Georgia for coming along today?
Brilliant. Absolutely. Thank you.
Well, thank you very much.
Thank you so much.